The last little thing that I can do regarding Helena Silverstein's book is to articulate my own, feelings about what we just read. Although I tried to somewhat on my other videos on this particular topic, it seems to me in my articulation of what I have come to understand about this and why and the grounds for which I would oppose the parental notification laws and the parental consent statutes would be that the ultimate case against them is just that, okay, first of all, the idealized parent, I have no problem with them being notified if they actually behave like a parent is supposed to behave, but there are unfortunately a reality of abusive parents in American society. They exist, people that shouldn't be parents in the first place. It would be naive to think otherwise and to proceed as if this is not a reality. Because of this, the courts have sought to balance in a compromised position between the two camps on this one. They've tried to achieve some kind of compromise on the basis of the fact that there is a judicial bypass process in place for these pregnant minors to actually go if their parents are not able, if they're not the proper parents in this whole thing. But our judges have been demonstrated repeatedly to not give a fuck, because they are so steadfastly committed to the idea that abortion is wrong in all circumstances and screw this and everything else, that they don't want to actually give these girls a relief. And you know we act as if we act as if, because of the fact that these petitions are normally granted, that the law is actually functioning and everything, and that it's actually working as it should, because of the fact that they usually prevail. They have a greater than even chance of doing it, and that that people will often act as if the number should be higher, of the failure rates in these cases. And I will give the parental rights crowd, I will concede to you that teenagers can be very secretive, but I don't think it's been properly demonstrated that teenagers maintain this secrecy even when they find themselves in deep shit, like a girl that finds herself pregnant when she's underage. I guess that what I'm trying to say is that there are usually limits on just how secretive a teenager is going to be. When a teenager finds themselves up shit's creek and without a paddle, you will off, so to speak, metaphorically, all rules of normal teenage rebelliousness and secretiveness tend to go out the window, because the teenager realizes that they're going to have to face the big dick of consequences, so to speak. And when that happens, they tend to reach out for support from the people that will support them, even if it's not necessarily their parents. It will be responsible legal guardians in a lot of cases. So this idea that the case that we needed a parental notification statute was never really properly articulated. And what I mean is just that they may have made a very good case for parental involvement and everything, but see, that doesn't mean that they've made a case for the fact that, in contrast to like parental involvement, that they've made a case for the fact that the state should compel parents to be involved and force the issue on these girls. Because in order for that to be justified in my mind, you would have to demonstrate to me that there is a regular and recurring, like, not just in the case of antidotes, but on mass scale, you have to have a very serious problem with teenage girls just naturally, almost always, or in a huge number of cases, choosing in a rather misguided fashion to behave secretively, even when it wasn't really warranted, to behave in that kind of way and try to conceal it from their parents, and that doing so was the actual norm, you know, and that we needed a bill to actually correct this problem that exists in society. That was never done. What was done was a passionate argument for, parental rights, and the fact that that outcomes for these girls tend to be a little bit better when their parents are actually involved in the situation, and that's not easy. That's not easy to argue against because it's ultimately obviously true. But the problem is just that this compromise doesn't actually function and work in the case of abusive parents because you know I know that the Casey standard, okay, will say that it's not necessarily an undue burden to put on these girls, but to me, like, it's more common sense to view things as a burden would be undue if it is unnecessary, if it doesn't need to be an obstacle in the way of these people, or it serves no real purpose other than fulfilling some kind of bias that we have. That would constitute an undue burden on the grounds that it just wasn't necessary. It didn't need to be there in the first place. And so to me, things like appointing a representative for the fetus would, meet my standard when it comes to that kind of thing, because this is just not necessary. It only serves a function of bias and prejudice against abortion. That's really all that it does, and thus it is not really a necessary obstacle to place in the path of these teenagers, and it does not serve me or my take on this that they happen to quite often overcome this limitation because it is a stressful experience that they don't really need to be put through. And when it comes to cruelty, we really need to ask ourselves if it is necessary, because if it isn't and people are engaging in it anyways, then it's pretty much a good sign of bad leadership. And I feel that this is an example of unnecessary cruelty that we are subjecting these girls to, these minors to, in this situation. So I have long been an opponent and outspoken of notification laws, but I've got no like interest in boinking teenage girls, that are underage, like kind of something that you grow out of eventually. So y- I just I can't, yeah, I can't understand this because like everybody's like you've got nefarious intentions if you're against it, and it's like no, I don't. Like I'm just concerned about the fact that there are cases of incest and abuse. That's really all that it is. And my further frustration to compound on top of that is just that the judicial bypass compromise that we came to in cases of incest and abuse has not really been working out too well, considering the degree and the leeway that the judges in these cases have towards judicial discretion, and how far that they have stretched these things beyond imagination and abused the degree of judicial discretion that they have under these things. The law that did come down and was passed down never did enough to bolt its definitions down enough when it came to the standards that were involved in these things, because it in the Bilotti that they were saying, the rulings and everything, they didn't really say what constituted mature. They didn't or what what they would define best interest as being in the case of these judicial bypass process. And because of the fact that they didn't provide a standard, we've allowed the judges way too much personal leeway over the process of what they're going to do with that. And as a result of the lack of control, it's been, broadly abused to a huge extent. And, maybe it doesn't meet the legal standard of abuse, but again, the legal standard for anything is always so ridiculously high that, it's stupid. It's ridiculous. Like, it always you always have to prove something to like a really high bar under the legal system. So I mean, Obviously, it isn't abuse in the legal sense, but I don't like who the fuck cares about the legal sense considering how fucking hard it is to actually prove anything to the standard of the fucking courts and the law. It's bullshit, and it's always been that way. And so you going you you know what I mean? And so saying that it isn't illegally abused doesn't mean much of anything because it is abuse, whether or not the law recognizes it as such or not. And I've got issues with this. I mean, we've got judges that are literally subjecting these girls to religious activities that they're violating the establishment clause under the Constitution that in multiple ways that provide these girls little other options because the only way to get what they through the process to the end result that they're trying to seek from the courts, they have to jump through the hoops that these judges have set for them that are just inappropriate hoops, making them go to a crisis pregnancy center before they're able, and having them subject them to religious indoctrination before they act. It violates the establishment clause of the Constitution. But the problem here is that even if it didn't, we also create problems because there are ways to get around that. You know that those objections, the establishment clause has been violated by simply sending them to a crisis pregnancy center and establishing one that was secular in nature and wasn't tied to religion. And then of course the secular pro-life people will be able to completely overcome all of those objections, and it opens up a massive loophole that can be and will be exploited. So it's like, because of all of these problems that now are exist under it, it kind of seems like there's a big and giant intellectual case against parental notification laws. And to articulate Helena Silverstein as well, it like the state and the courts are not really prepared ultimately or capable of actually providing adequate redress for minors in this situation who find themselves pregnant and have abusive parents that they don't want to find out about the whole thing. It really just has not managed to provide adequate redress in this scenario. The courts have proven to be either ignorant, incapable, or recalcitrant and opposed to abortion, so much so that they behave in a rather prejudiced manner against it. They've set up what amounts to harassment by the courts by forcing them to be subjected to an attorney that is basically on the side of the unborn fetus. The it's on these grounds that I'm just like, let's keep it this way here in Oregon and not have a parental notification or consent law. Because it just, I know ultimately that outcomes are better for teenagers who have parents involved, and I'm saying that it's good when that happens, and it's good when they actually come forward and tell their parents about it. But we can't really count on the fact that you know that every parent is going to be a good parent, because as Helena Silverstein pointed out in her book, there were cases of people that were forced to do it, that they notify her parent and the whole thing, that after having impregnated her, killed her, and the whole, yeah, he murdered his child that he had knocked up. I mean, I've sloganeered about that myself and said about cases like that, not even once. One case like that is too many, and it's happened apparently. So I I just I know that not every parent is a good parent, and unfortunately, the legal system tried to come to, a compromise, but it didn't really account for the possibility that you were going to be beset with judges that were going to inflict their personal biases and conflate their personal opinions with the interest of the state. You know, that the argument and articulation by so many of these people has been that the state has an interest in childbirth over abortion strikes me as a very bad argument, because it's it's not that I guess you could say that why it's a bad argument is because it conflates the person who's making its interest and their opinions with the interest of the state, which are not necessarily equivalent. And just because just because a person is like a government person, like they're an agent of the government, and they serve a government role and in function in the government, doesn't mean that their personal interest and their personal preferences are necessarily the interest of the state just because they happen to work for it. It seems fairly logical to me that, the state really, its interests are ultimately in things like actually, having its coffers, you know, balanced and paid off. And if it could be demonstrated to be true, for instance, that the state actually did better as far as the money coming in the door in the case of somebody who aborted the child rather than the economic impact that bringing that child into the world would be, then it would actually be quite the opposite. And the state's interest would actually be in abortion over childbirth. So it's strange to me that these people are trying to argue that the United States government has an interest in childbirth over abortion, because I'm like, what? You've got to you've got to explain why exactly it does the government better if a child is born. Because if you can't make a case for that, then you can't really say that the state's interest is in this. I don't, I don't think the United States necessarily does better, because people do financially better if they don't actually have kids. So, I there was a lot of bullshit in that book that I had to read about the courts and everything else and what people were saying. I mean, it was just a bit of a headache. I mean, I see the state trying to make this argument, and I'm just like, you're a fucking agent of the government. You are not the government itself. You don't define what the state's actual interests are, ass clown. I mean, you're conflating your personal preferences with the interest of the state. I find all of this really troublesome, and it's on the grounds of all this shit that the state really just isn't able to, and has proven itself woefully incapable of actually implementing the judicial bypass in practice. And when they have, they've subjected these teenagers to burdens that, under any reasonable standard of undue, would would not meet the expectation, would be considered undue. But of course, Casey tries to bolt down what constitutes an undue burden to the point where it's like you have to prove that it would cause an almost certainty of people failing to meet the burdens at hand. And I'm just like, that's a ridiculous standard, because you know a reasonable definition of undue burden would simply be, does this burden really need to be in place in the first place? Is it necessary? If not, then it's undue.